Welcome to the Future Resolution, Miles Mediation and Arbitrations podcast. On today's episode, we have Roger Quillen, Chairman and Top Executive of Fisher Phillips, one of the top employment law firms in the U.S. The firm has 40 offices and nearly 450 lawyers nationwide. Roger shares insights and emerging trends in employment law and predictions on how the field will evolve in the future. He's interviewed by Miles Neutral's David Nutter and Nigel Wright.
Roger, thank you very much for spending some time with David Nutter and myself to talk a little bit about Fisher Phillips. And what we wanted to do was just start with asking you to provide us with a brief overview of what your role is at Fisher Phillips.
Okay, thank you. And I'm happy to be with you today. So my title is that I'm the chairman of the management committee, which is our board of directors at Fisher Phillips, and the managing partner. So in a sense, I'm chairman of the board and CEO of the whole organization.
And can you tell us what your firm is predominantly known for?
We are one of the country's best known brands when it comes to workplace law on behalf of management. So we define our practice as covering everything that arises in the working relationship, and as I say, always on behalf of management.
Roger, you've been in Atlanta since 1980.
Yes, sir.
And hail from Ohio, right?
That's right.
Tell me, you joined Fisher Phillips right out of the box out of law school when you came to Atlanta. Tell me what Fisher Phillips was in 1980.
So Fisher and Phillips, as we were known at that time, we didn't even have an LLP on the end of it then, just Fisher and Phillips. We were what was described in those days as a labor law firm. Nobody spoke back then of employment law. It was labor law. And I was lawyer number 36.
Wow.
And the firm existed only in the city of Atlanta. It was common in the time. When I was looking for a job as I approached my last year of law school, as I was looking around the country at the best possible labor law job, because I knew for sure I wanted to be a labor lawyer, and we can talk about why later because that has to do with my background, you would choose a great labor law firm by, in a sense, deciding what city you wanted to live in. So the great firms in our space in that day were in one city typically. And you knew that if you wanted to go to San Francisco, you might know the firm you wanted to go to, likewise New York, likewise Chicago. And in Atlanta, the premier brand was Fisher and Phillips. And my labor law professor at the Ohio State Law School told me that this was exactly the kind of law firm I should want to work for because they, as he put it, if you go to work at a firm like that, you will have an opportunity to make the law we practice. Wow. And so that was intoxicating to me, and I came. But I didn't know a single person in the state of Georgia.
No kidding. Yeah, so what about your background growing up in Ohio made you know you wanted to do labor law at the time?
So I'm a blue-collar kid. I grew up in a family with a Teamster truck driver father and working-class family, working-class laborers as far as the eye could see in my family. I put myself through school by working factory labor in the summers. I was a union member every summer. I was a steel worker for 2 summers, rubber worker for 4 summers. And so by the time I got to law school, I loved workplace law. And I knew I wanted to be in it. But I would have bet anything I would have been a union lawyer.
Right.
And so law school had a lot to do with how I ended up. On management side, my law school professor was an outstanding person who presented the field in such a balanced way that I, for the first time in my life, came to realize that management might have something to say for itself as well.
Yeah.
And so I sought jobs on both sides of the fence, and ultimately the best jobs turned out to be on the management side.
But I gotta believe that I worked in a textile mill myself one summer. I gotta believe that background has given you tremendous perspective as you've practiced labor and then employment law over the last 40 years. That's an amazing story.
Sure has. The best part of my education, no doubt, has been what I learned on the plant floor. If you want to be an employment lawyer, you've got to understand workers, and I think it helps if you love workers. I've never lost my love of working people, my respect for working people. And while I ended up advocating on the other side of the fence, I think I've done a lot of good for a lot of working people who don't even know my name by helping employers be better employers.
Yeah. And so you get to Atlanta, you said your number, was it 32, did you say?
36.
36, excuse me. And today, Fisher Phillips has a few more than 36 attorneys, doesn't it?
Yeah, it's just a coincidence, but we have 36 offices.
I was going to comment on that.
Yeah, we just opened our 36th office on January 1 in Detroit.
Wow.
And over 450 lawyers. So yeah, very different law firm today.
Okay, and you've been the managing partner for 15 years?
Actually, more than 20, and I'll have my 20th anniversary as the leader of the firm on June 1st.
What about your whole background prepared you for what you obviously are an amazingly successful leader of a large organization? What about your whole upbringing, background, and as you started, led you to be so effective at what you're doing now?
Oh, great question. My early training in college was in mathematics. So when I made the decision to go to law school, I was in the middle of a graduate program at Purdue University intending to get a PhD in math.
No kidding.
So I will say I have a tremendous faculty with numbers and analytical thinking. So that helps. But I would also say the small town values I grew up with, again, the respect for people, learning how to get along with people, people who aren't at all like you, all that added up to somehow give me the package of traits that our partners respected enough to ask me to be the leader.
I don't know, you maybe have written internally or externally a little leadership book, but do you have some core leadership principles that you would want to share for those who aspire to lead a large organization?
Yeah, I'd be happy to. To quote the great philosopher Woody Hayes, he wrote a book entitled "You Win with People," and I've always believed that the best decisions an aspiring leader can make is to choose the right people, empower the right people, reward the right people, and if you do that, your organization will go through the roof.
Yeah.
You've got to start with the right people. People sometimes ask me, how do you manage a law firm that's now 36 offices that are connected mostly by email? How do you do that? And the answer from me is right back to that same principle. If you choose the right people to start with and you empower them to do what they're already good at, then you can build a great organization.
How do you empower people?
When we approach a group of people to join us, we do a lot of vetting of them for what is their personal philosophy, what are their core values, their principles, what really makes them tick. And if we feel that there's a fit with our values, which is very client-focused, very much about adding value for our clients and putting our clients first, if we feel that fit is there, then we really do very little to meddle with the way they choose to continue to run their operation. So they have to do some things exactly as we do. Some people in management theory call that hygiene. They have to record time. They have to send bills. They have to collect them. They have to do some things just as we do. But we allow them to do what they do well. And we just don't interfere with that once we've decided that there are our kind of people to start with.
Roger, I noticed on your website you set out what Fisher Phillips's commitment is to its clients. And what I saw was that you have a number of principles which set you apart from your competitors, and obviously I'm sure that has significantly contributed to your growth. But what I wanted to understand is what does Fisher Phillips mean when it says that your attorneys need to have a commitment and understanding of the business and industry of their clients?
So the thing I've learned by visiting clients and asking them, what makes you really happy with your outside lawyers, whether it's us or some other law firm? What makes you happy? I've heard several things from them, and one of them is that our lawyers know our industry, they know our business, they know our definition of a win, and they design their or execute their practice for us to help us succeed in the way we define success, not the way they might define success. So that's fundamental, is to understand the industry, understand the business, understand the client's definition of winning. So I would say that's a huge part of it. But I'm also, when I make those visits, I'm asking clients to just give me their list of the traits they prize in outside counsel. And we try to constantly refine our brand promises to fit what I'm learning from those clients.
One of those I saw was near fanatical responsiveness was set out as a differentiator and something that your firm is committed to. Having been a client for a number of years, I never really understood that prior to being a client, but being a client, I completely understood that. I think we live in a world now where responses are expected to be immediate. And how do you deal with that, particularly when employment crises can occur outside of regular working hours?
So what we teach all of our lawyers and expect of our lawyers is that we want a client who contacts them to have the impression, as false as it might be, to have the impression that that lawyer is just sitting there waiting for that client to call. And in order to do that, you have to respond very quickly. So we say to our lawyers, if you are in the middle of a deposition where you cannot give any kind of real time and attention to a client who's trying to reach you, you at least owe it to them to let them know, hopefully within minutes, but as soon as you possibly can, that you are tied up. You will not be able to get back to them until X, but you will tell them when they can expect to hear from you.
I mean, that's really excellent to hear. I do remember when I was in my in-house role, there was a particular attorney who I actually tried to give quite a lot of work to. And every time I used to contact them or follow up with them, they always used to tell me that they were terribly sorry they hadn't done my work, but they were busy on something else. And it got to the stage where I couldn't try any longer. As good as this particular attorney was, their responsiveness just wasn't there. And it's a lesson that I always try to instill amongst my team. And I'm really glad to hear that it's something that Fisher Phillips takes so seriously.
We recalibrate on this all the time. So just recently in December, we had all of our local office leaders together for a meeting that's an annual meeting for us. And this was, once again, an agenda item. How can we live to that brand promise? And we asked for a showing of hands, and we asked for people to tell us, what do you do in your office? And the entire range of responses we got was an office that said, we expect our lawyers to respond to any client inquiry within 20 minutes. Now, by the way, if you're on an airplane and you can't do that, then obviously you can't do that. But
sadly, you can actually do that these days with an email.
And we expect our lawyers to sign up for that service to be ready. But I did hear there were other offices that said, we don't aspire to that. That's outstanding. We don't aspire to that. But the worst I heard was 4 hours. And while that doesn't make me perfectly happy, it goes to show how hard everybody is working to try to live to that responsiveness thing.
Yeah. Other core values that you would say are distinctive to Fisher Phillips that make it who it is as a firm? Other core values?
So our brand promises really, they really consist of these two things, that we will commit ourselves to know your business and to know your goals so well that you will come to see us as a valued partner in achieving your business's goals. And the other one is to promise an outstanding client experience every time, everywhere. Now, obviously, that's an aspirational statement. Sure. Because you do sometimes fall down and disappoint, and that's grievously bad when we do, but it happens. But we teach the principle in-house that Our brand promise is only as strong as our weakest link, and you don't want to be that weak link.
Right.
So those are the two things that we believe distinguish us. Now, because we focus so hard on growing through the acquisition of outstanding people and people that we consider to be a great fit for us, it goes almost without saying that our culture is a very pleasant, very mutually supportive, even fun place to be, because we don't knowingly ever hire an outlier. And if we find that we have hired an outlier, we try to get them out as soon as we possibly can. Because again, by choosing people, by building around people first, you can build an organization of people who really enjoy being there together.
Right.
When we bring our lawyers together, every other year we have an all-partner meeting live, and then in the other year we have an all-attorney meeting live. This year it's all attorneys in Denver in just a few months. When we bring those people together, it is an absolute love fest. In fact, every year when we publish a survey and we ask, how do we do? How can we do better? The only thing we hear consistently about what we could do better is, please give us more time just to talk to each other.
Wow.
Our lawyers love spending time with each other and cross-pollinating.
Wow.
Roger, can I ask, have you done any training or have you been on any courses relating to management, or is this just an organic philosophy that has emerged, maybe because of your personal background, maybe because of the firm's history? And do you think that those sorts of training courses can help?
Well, first I'll admit I was completely unqualified to be the leader of a law firm. It just so happened that at that point in the firm's history, 1997, when I was first elected to the management committee, that the atmosphere or the environment at the firm was right for me to emerge as a candidate and to be elected. I was 43 years old, and it seemed too young for it. I had no management training, no management experience of any kind, including within the law firm. Initially, I got my training from the firm's then COO, who had come out of the Army's military leadership program. He was retired at lieutenant colonel. He took me under his wing, and he shared a lot of leadership principles with me, and I so appreciate him. But I then was just, I was benefiting only from on-the-job training, which isn't a very good way to do it, I don't think. Until in 2002, I joined an organization, a CEO organization, and that organization had me attending a meeting once a month. If you don't mind, I'll tell you it was Vistage. Back in those days, it was called TEC, T-E-C, and then the name was rebranded to Vistage. And it's an organization. To be in it, you have to be a CEO. And so those monthly programs involved speakers and workshops, and I have to credit Vistage in a big way. It gave me essentially an executive MBA.
Wow.
And can I ask, do you think that training has helped you in your negotiations when you're acting on behalf of a company?
I don't think that training did. I would say the fact that I was groomed and raised as a labor lawyer in this law firm certainly did. So from a very early stage, I found myself being called upon to settle disputes and to sit at a collective bargaining table. I mean, I negotiated my first serious union contract when I was only about, 4 years out of law school or something. So that's something that a labor lawyer does get a lot of training on. And I have been to programs before where we were workshopped in how to get to yes. So I consider that to be very valuable, and I do think my career was boosted by receiving training.
Can I ask, does your law firm employ or retain mediators on a regular basis to try to resolve disputes, or do you feel that with your background, it's something that most of your attorneys are able to address in a two-party negotiation?
We very often use outside mediation help, very often, and find it super valuable.
Are there any particular traits that you look for when you're selecting a mediator?
Yeah, there's one that just trumps everything else. Can they cause the parties to reach a deal? To me, if there's one statistic that I want to know about a mediator is how many times do you end with a deal? And if that number is 95%, that's a mediator I want. The most frustrating thing in the world is to have a mediator who's trying to get along so well with everybody that they can't force the parties to reach an agreement before they walk out of the room. And to me, that's just a disqualifying feature of a mediator.
Yeah, I actually read an interesting article about that today, and the article basically said that it is possible to have too much emotional intelligence, because if you have too much emotional intelligence, then you are concerned about upsetting one party, which means that you're trying to get everyone to get along, and consequently that can result in an impasse because you simply don't want to say what needs to be said to get resolution.
I completely agree. In my job as the leader of the law firm, I've been in some, I would say, very unpleasant mediations trying to resolve disputes. And they were the most productive ones. The ones that were miserably uncomfortable were the ones that resulted in a deal. So the first time I was ever in a mediation on behalf of the firm, it was with a disgruntled partner who was leaving, threatening to take legal action, and there's just nothing worse than to have a co-owner, a fellow owner of the law firm who is so unhappy with the situation that they are not simply willing to leave, but they are rattling their saber against their own institution, where they have an ownership interest, and nothing worse. And we hired a mediator who was reputed to be able to get a deal. I think it was literally 95% of the time. They published statistics on this person. And I went in there, and it was about the worst, most miserable day I think I ever spent. It felt like it would never end. But that mediator kept us there, absolutely would not tolerate us leaving. I mean, it's amazing how the mediator asserted that power, not having it. It's just remarkable that a mediator could do that. Me, the leader of this national law firm, making me feel that I had no power to get up and walk away. Incredible. But we got done. And that's left the biggest lasting impression on me, was that pain is what allowed us to get to a deal.
Okay, no, please.
Do you think the same approach works well when you have an employee of a company, where that employee may be very emotional about the circumstances leading to them being in front of a mediator, or do you find that a strong mediator actually helps bring a fair resolution to that particular dispute?
Yeah, so that one is to me, a little more complicated if there's vastly different power between the parties. Mm-hmm. And so my feeling when there's an individual employee who's not a high-level executive, let's say a rank-and-file worker, who's brought a claim of, say, workplace harassment or something, my experience, and I think you would hear the experience of our lawyers, is that very often that person has not had their, quote, day in court. They're dying to be heard. And in some ways, what the mediator would bring to the table in that scenario is that the person is being heard.
Right.
And if they feel they've been heard, even if they're being told in the end, your claim is very weak, you probably ought to take the deal that's on the table and go, then I think the mediator can make all the difference. So, yeah, obviously a good mediator has to scale their behaviors to fit the dispute and to fit the parties. I'd say if it's a party that is by far the weaker, then the mediator probably ought to, in fact, be maybe a little softer on the surface and come across as being a good listener. Because sometimes that's the main thing that person's looking for.
Yeah. How often does that, being a good listener, come into play in your role?
It's absolutely huge. I think, to me, a good leader has to have empathy, has to has to really understand where the other person is coming from, and to validate the person's feelings. You don't have to agree with them, but to validate their feelings, to let them know that that they're not disrespected in the process, I think is huge.
What to you is the most difficult part of your job?
I think it's the people part. I love the numbers, you can imagine, with given my math background and all that. I love spreadsheets. I love key performance indicators. I love projecting firm performance and tracking how we're doing against the number target. Love that. I'd love to live there all the time.
Right.
But the hard part is that we are a business of people fundamentally, and so I would say the things that probably take the most of my time and certainly the most of my energy is dealing with the people side of the organization.
Okay. Yeah. So you've experienced this tremendous growth in the last 20 years. Remarkable. What do you see as the industry trend lines that brought that to bear, where you came along at the right time to make that happen? What's going on that's causing that to happen?
I should write a book on this someday because I've thought so much about it. So I can trace the history of national expansion in employment law firms to pretty much the Civil Rights Act of 1991. So until then, there was no such thing as a jury trial in most employment disputes. Under Title VII, which was the lead law in employment discrimination, and many, many other laws that we practiced under, there was only either an administrative agency to resolve the dispute or a federal district court. So no juries. So a law firm like Fisher Phillips in Atlanta, up until that time, could operate very, very well in one city, sending its lawyers all around the country. We might have an office somewhere because we had a sense that we were losing market share by not being there. And so that explains why we went into South Florida and into Northern California, was a sense that we had a very large market share that was at risk.
Right.
But we didn't have to have lawyers there to handle cases so much as to handhold. But wow, that Civil Rights Act came along and put jury trials into the world of employment law. All of a sudden, sending an Atlanta lawyer into New York, New Jersey, California, and many other places to stand in front of a jury as an outsider like that with a Southern accent, that was not going to work. And so no coincidence that about the time that law came into play, firms like ours began to blow up with national expansion. There's no doubt in my mind that was the big driver.
Fascinating.
I was going to make a flippant comment that as an Englishman wandering around Gulf Shores, Alabama, in the various courthouses down there, I didn't really understand what you're talking about, Roger.
Yeah. Now, let me just continue with the theme, however. The thing that is driving our huge growth now is actually something that's much more recently on the scene. There has been and will continue to be an explosion of state and local regulation of the workplace that didn't used to exist. So when I came from law school in 1980, if you had asked anybody in our law firm, what are the laws you are practicing under? It would have been in every single case, federal. Federal agencies, federal courts. There's been a tremendous change in that, so that it's state laws now that are driving the action, state and even municipal laws. You see that in so many places. Our law firm, if you go on our website, you would notice that as we were closing out 2019, we published an article that talked about the most important developments in our field in 2019, and there were 50 numbered items there. Of those 50, probably 30 of them had to do with state law. Everything from state wage and hour law, which is radically different than federal, to gender equity, pay equity, data privacy, hostility to arbitration in the workplace, cannabis laws, cannabis in the workplace. on and on and on and on. State, 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 state. So one of the reasons that we're expanding even now, even with as many offices as we have, we still are looking at other cities, is because our national clients can't just turn to us and say, tell us what the law is on that. The law is different in practically every state in the country.
You touched on a couple of points I was going to raise with you. There are a number of issues in the employment world which seem very topical at the moment. Marijuana law is obviously one of them because it's legal in certain states, illegal in others. You have firms with a national footprint, and you have the potential for conflict between the company's rules and regulations, for want of a better word, and state legislation. Is that something that is driving claims, in your view, or is that something that you're just having to manage at a local state?
It definitely drives claims. There are some states, not many, but California, of course, would be the one you would expect, that has a state law that says you cannot discriminate against somebody for their choice of recreational activity. So if somebody wants to do something when they're away from work, then that is a protected activity unless it impacts their actual work performance for you. And so there will be people who will claim that their use of cannabis away from work is somehow an underlying reason for their treatment in the workplace, and that can lead to a claim.
Another area which I know is a hot topic at the moment is the issue of overtime pay for so-called independent contractors. And as states and the federal government look for more revenue, my understanding is that there's a trend towards independent contractor arrangements being scrutinized much more closely, certainly from a revenue collection perspective. Is that something that you're seeing?
Absolutely true. One of the biggest areas of concern and dispute out there is that definitional difference, distinction between independent contractor and employee. And so you're right, it would be bad enough if this law was changing at the federal level, but then you have states all over the place who have their own ideas about that. It's huge as it affects the gig economy. So many gig economy companies, and I'm trying not to use the word employers because they don't think they are employers. So many of those companies are relying upon independent contractors. And yet you're absolutely right that employee advocacy organizations and governments are seeing that as an area for interest for them, and revenue being part of the motivator for governments.
And that, of course, is going to impact other areas of law, such as the protections that employers have for employees who are injured on the job, and whether or not an independent contractor can maintain a claim in the event that the revenue collectors in the particular state deem them to actually be an employee. So I think it's going to be an interesting area to watch.
It will be. If you think about workers' compensation laws, I assume that's what you're talking about. Workers' comp laws it's a two-edged sword. On the one hand, it is something designed to protect the employees in case of a workplace injury, but the exclusive remedy doctrine, which says that if somebody has a workplace injury, the exclusive remedy for that is the workers' comp system. That's a huge protection for employers. So maybe what you're alluding to is that if the employer gets its way and wins the argument that these people are independent contractors, then they've just removed themselves from the protection of the exclusive remedy doctrine, and now they may be liable in tort for injuries to the independent contractor.
And vice versa, you may find independent contractors seeking to argue that they are in fact employees, and the various states involved may actually assist in that process by redesignating what constitutes an employee.
Right. So one of the reasons an independent contractor might argue for that, they do want the protection of wage and hour laws. They want to make overtime pay. They also want to become eligible for benefits under the employer's employee benefit plan. One of the first big cases that occurred in this area was out west. One of the great, big, famous high-tech companies believed they had a large class of independent contractors, those people actually prevailed in claiming they were entitled to benefits under the retirement plan. Super costly.
Talking about costly, to what extent do you think that the changes, which are not so recent these days, in relation to the recoverability of attorneys' fees in class actions has impacted the employment world?
Well, it's an absolute cottage industry out there for some lawyers, some teams of lawyers to bring class actions in employment cases, and the attorney's fees makes it very attractive for them to do that. So, but I would say, however, that trend was much greater some years ago. If you turn the clock back to the late 1990s, maybe very early 2000s, there was a rising tide of major class actions bringing discrimination claims, one famously against Coca-Cola here in Atlanta, but certainly that wasn't the only one. And there was a specific team of lawyers that was going around the country targeting those employers. The federal courts really cut back on that. I mean, the Supreme Court trimmed their sails and made it much more difficult to bring those actions. But that just caused them to go to the states. And so in states where, like California now, it's popular wisdom out there that a plaintiff's lawyer automatically commits malpractice per se if they bring a claim in federal court because their remedies and likelihood of a good outcome are so much greater in state court. And that's super true in class actions.
Do you think that the trend against the class action lawsuit may in many ways be driven or contributed to by social media and maybe a little bit more corporate enlightenment by some of the larger corporations who would be targets? And what I'm really talking about there is that the dissemination of information is so much quicker today. And so what's acceptable and what's unacceptable is much easier to identify than perhaps it has ever been. And so in that environment, my experience has been that many large companies are seeking to make sure that not just to comply with the law, but just philosophically take a balanced view to how they treat people and perhaps improve on areas that may not have been dealt with particularly well in the past. Is that something, presumably in your consultant area, that's something that Fisher Phillips would very much be involved in?
I definitely agree with your observation. The rise of social media, the rise of public shaming through social media is one of the biggest trends and the biggest social forces going on in the country right now. Yeah. No doubt about it. I don't know if you could say it began with Occupy Wall Street, maybe. Certainly the Me Too movement, the Not Here movement, the Fight for 15 movement, the 15-hour minimum wage. These social media movements have such force now, such power to damage the brand of a company that you're absolutely right. A company that's really, at least a national company with big reputational risk, they must have their eyes on that. And so you must be paying attention to compliance in a way that's much greater than before because the risk is so great.
Yeah. There's a tension, isn't there? I mean, you're a leader of a pretty large organization, from my viewpoint. Obviously, there's larger out there, but you got a lot of lawyers, a lot of employees, and you talked about you have a brand, you have a culture, you can tell when maybe someone's not going to be a fit for your culture. And then as the employment laws continue to expand on the local level, does it present challenges for any organization to maintain a certain unity of culture and brand amidst the expanding arena of employment law in the areas that are off limits to what an employer can be trying to shape as their firm culture?
Yeah, it's a good point, and it's a challenge. I mean, I have to admit, just like any other organization, we have people who become disgruntled and disaffected, and when we see that, we have two challenges, just like any other organization. One is the potential legal challenge.
Right.
But I must say, I consider that now to be the smaller of the two. It's that brand risk that is the much bigger thing. So I would say, and we do say to our clients, it's not just about having the superior legal argument or being able to win this case, because there are much bigger things in consideration. So I would say a lawyer today, to be a good lawyer representing companies, you have got to be a full-scale trusted advisor, helping your client understand there's more at risk than there was maybe 10 years ago.
Yeah. I see this in a decent amount of mediations across the board, employment and others. There's a lot of disputes that could be avoided if people didn't act as quickly.
I so agree. Again, this comes back to empathy, I think. I'm not going to tell the story in any detail because it would be embarrassing to somebody, but we faced an unpleasant situation within the last 2 years because an employee who was a substandard performer had been counseled, and now it was time to terminate. And at the termination interview, where it had already decided that what's going to result here is a termination, the employee for the first time said, "Would it make a difference to you if you knew that I've been going through the following?"
Oh boy.
And our person in charge of that situation, thinking only in terms of a defense against a legal claim, very quickly said, "No, wouldn't make a difference." Now, 10 years ago, that would have been exactly the right thing to do, because you wouldn't want to have the knowledge that employee was about to give you, because then it could be used against you.
Right.
But golly, what that employee walked out of there with was, that person didn't care about me at all. I was trying to tell that person something that is really important for me to get off my chest about my situation, and that person said they're not even interested to hear it. Had it been handled a different way, I believe there would have been no employment dispute. But that triggered it.
Wow.
Well, just on that topic, another current trend in employment law is that of accommodations. And in particular, large companies or companies have to give consideration to requests for accommodations and go through particular protocols to make sure that they are given proper consideration, which in many ways is similar to listening and hearing somebody out. Now, ultimately, the decisions going to depend upon what the applicable law is and whether the accommodation sought is fair and reasonable and consistent. However, that obviously takes up a lot more time, a lot more management time within those companies. And are you finding that the HR departments of large corporations are expanding as so many more issues are being raised than perhaps may not have been 10 years ago?
Yeah, I think we do see that expansion. In fact, we see our large corporate clients, our national clients in particular, building up their in-house resources significantly, even to the point where they're beginning to pull some of the work that we might normally do in-house. We do see a big trend of that. Now, I've been around long enough in my 20 years of leadership to have seen that trend, that pendulum swing back and forth.
Right.
But I would say the pendulum right now is swinging in the direction of the building up of in-house resources. Now, to that specific thing you're mentioning, though, accommodations, that's a classic example there of how 10 years ago, before social media became a big force, a company might have handled that in a very technical way. Nope, that accommodation you're asking for is not reasonable in the circumstances, and so the answer is no. But today, you've got to ask yourself, before you act so quickly, am I willing to live with the social media consequences of the story being told on the street? That this person came forward seeking this help, and our answer was just flat no. Just have to be careful. Can you stand the social media heat from being too quick to decide?
Right.
Roger, one of the things I've learned from chatting with you today has been that as a company, you need to continually look at what your internal terms and conditions are and your handbooks and guidebooks, and that the once a year 1 hour seminar on have you done this, that, and the other maybe is not enough today, and that I think maybe large companies need to, all companies rather, need to think a little bit harder about how they are ensuring that they as companies are complying with an ever-changing and more complex legal environment.
Yeah, you're absolutely right, because the ground is changing continually. So I don't mean this to be an advertisement for us, but I would say that that a company needs to have someone, whether it be their lawyers or insurance brokers, they need to have somebody to turn to for continuous information about the changing landscape. So our clients know they can go onto our website anytime, and there will be the freshest information, state by state by state, is going to be there, because our lawyers are capturing those changes constantly, and they're writing articles about them constantly. So we happen to be a rich source for that. All of our major competitors do the same thing. Insurance companies do the same thing. Companies need to have their chosen source for that information.
What do you see for the next 10 years for Fisher Phillips and the industry in terms of the trend lines you're seeing? You've done this for 20 years. What's the next 10 years going to look like for your firm and really the industry you're in?
So one answer is that technology will continue to change the landscape rapidly. The rise of artificial intelligence, knowledge management, project management, interface with our clients through technology. Think of this, 10 years ago, if you just said, Roger, what do you consider the ideal IT department to be? How would you know you had the ideal IT department? I would say, when I forget I have an IT department, that's when I know they're awesome, because I don't want to hear about any problems with email or internet connectivity. That would have been sufficient. And that's just laughable today. What you want from a great IT department now is an outward-facing, robust platform that engages with your clients and allows them to come and look over your shoulder and participate. And it has to be a robust two-way street. So that will continue. Our competitors, we and our competitors, are in a race to develop apps that our clients can use to get quick, easy solutions. We don't make any money on that. It's just a service we provide. But if we don't provide that service, they'll go somewhere else. So there's so many things we do today that are all about client service that aren't even revenue generators. It's all about creating a stickiness in the relationship. Yeah. So there'll be more and more and more of that. But a new threat on the horizon, and I don't know how to assess it yet, is the very likely arrival of outside investment capital in the world of law. Mm. And so, in Europe and the UK, that's been the state of things for quite some time. The largest law firms in the world aren't even law firms anymore. They're consulting firms that have huge in-house legal departments. So there's the threat of that coming into the U.S. And the ABA will probably take a stand against it, but the state of California has already announced that, I think in 2023, I could be off a year, they expect that to be the case. They expect outside capital to be able to begin to get involved in creating alternative avenues for legal practice. Wow. So sometimes people ask me, so what keeps you up at night? And I have to say, the unknown of the effect of that outside capital coming into the legal profession, it could be a real game changer. And I wish I could tell you how I think that will play out, but I don't know. Probably the best clue is to look at what's already going on across the Atlantic and to see how that has changed things over there.
Mm-hmm. Yeah. Well, it's interesting that legal jurisdictions overseas have very different rules which actually make the deployment of that capital a little bit more challenging than, in fact, they may be in the US. I mean, for example, the UK, which obviously I'm very familiar, the loser pays the winning party's costs, which is a big incentive to resolve a case well before trial. But it also enables parties who don't believe they have exposure to take a case to trial, because if they believe that they can recover that capital that they have outlaid themselves, then obviously they may wish to take that particular route. And of course, you also don't have jury trials over there for civil cases. And of course, in Europe, you have different civil codes which apply, and discovery is very different, and it's just a completely different process, where often the judge is the investigator and retains external experts. So those make the deployment of capital in those jurisdictions slightly different. But I think certainly in terms of large cases, which is what the hedge fund money is going to be looking for, the venture capitalists, those cases are probably primarily, I would imagine, going to be in the casualty side, class actions, because that's where they can get a return on the amount of capital that they have deployed. So,
I'm actually thinking of something else, though. I mean, your comments are apt, but I'm talking about alternative providers of legal services, new forms of competition that will come in and say, you don't even have to go to a law firm for this. You come to us, we have in-staff lawyers, and we will take care of all your employment law needs. That's a very big potential threat.
Yeah, the Walmart of law.
Yeah. Think about H&R Block when it came to simple tax advice. Not H&R Block, I'm sorry. What was the name of that? The law firm that guy. I definitely don't mean H&R Block. I can't think of it now. It was on the front page of the American Lawyer when it happened. That guy rocked the legal world when, Joel Hyatt and Associates.
Yeah, right.
Yeah, when he created that different kind of law firm.
Yes.
Well, if outside investors, if somebody could say, look, I've got $100 million laying around here, I'd like to invest it in something that can get me a good return in the future, that person may say, I think I'll create an alternative legal services organization.
Yeah.
Now, today you can't do that. A member of the bar is not permitted to share fees with somebody who's not a member of the bar.
Right.
But if that is ever broken down, that will change the game in a big way.
Yeah.
it is interesting. In the UK, as you know, there are some law firms, in fact, listed on the stock exchange, which is very nice for the partners who were fortunate enough to be partners at the time of the listing. But it does, as you say, raise some significant issues. It hasn't led to a tremendous disruption in terms of the types of services or the way that they have been provided. And I wonder whether, as much of a threat as alternative capital is, whether AI, artificial intelligence, might in fact be an even greater threat, because that is threatening, if you want to use that word, to take away a lot of attorney functions.
I absolutely agree. Yeah, in fact, I named that one first. I think the rise of technology as a competitive force in our field that's a big game changer, and I wish I could predict how it will go. But there might be an analogy that could give us a little comfort if you're on my side of this conversation. 15 years ago, maybe 20 years ago, I had somebody who was a friend of mine, who was a lawyer, who said, you guys, you're going to be like the dinosaurs. You're not even going to be around in 10 years because the answer to all legal problems can now be given by somebody in India who's working for 1/10 of what you're paying your lawyers. And it's the offshoring, the outsourcing of legal solutions that's going to put you out of business. And what a happy conversation that was for me as the young managing partner of Fisher Phillips. But it didn't turn out to be true, and it was not true because at least our clients still greatly treasure the working relationship with a person who they believe is invested in them and their outcomes and has taken time to know them and their goals and their businesses and industries, exactly those brand promises that we make. So while AI will be able to tell somebody what is their potential exposure in a case where they want to, if they imagine picking up your phone and you say, I'm thinking of terminating an employee, and the AI comes back and says, what's the gender? What's the age? Is the person pregnant? Et cetera, et cetera. They ask them a lot of questions. And then in the end, okay, and so you have potential exposure under the following statutes. What more is AI going to do? I mean, is AI going to advise them how to handle that? I don't think so. And if it could, I think the client would rather be sitting across the table from a human being getting that advice. So, I don't know.
Yeah. Let me ask you something. You deal with a lot of the younger generation. I mean, the firms growing. Tell me, I hear a lot of talk about, the younger generation coming up. Tell me something about the younger generation of lawyers coming out of law school today. You'd say, man, in that way, I think they're better than we were 40 years ago.
I could definitely say that. I'm not a guy who bashes the millennial generation. I think they're awesome. I better say that I have 3 kids who are all millennials. I think the sense of ownership in their careers that they have is phenomenal. I don't think they come expecting that they're just going to be slowly spoon-fed and being given a career. In fact, what I see is that they are impatient and eager to learn fast, make a difference. They understand that they are individual enterprises in a sense, and they get that. So what I see from our millennial generation lawyers is they are the most likely to say, I want to take on a charitable project. Would you empower me to run this if I'd be willing to spend the time? I mean, they are self-starters. I love them. I really respect them.
So, Roger, let me ask you this. Do major sporting events, Super Bowl, Final Four, that sort of thing, create unique problems for workplace claims and that your lawyers have to handle?
Absolutely. It's one of the, I have to say, we have to chuckle every year when it's March Madness time, Super Bowl, the Masters, all those things. So there's almost a stock list of problems that arise in the workplace. One of them is those events have the opportunity to practically shut down your internal IT system. The traffic load on our servers during the World Cup is so bad. The Soccer World Cup is so bad that we have to send out reminders. Look, please stop with the video streaming. I mean, we almost can't use our system. It's so bad. Wow. But there's the issue of office pools violating gambling laws. Of course, the drinking that goes with the parties that go with these things can be a big thing, especially if it happens to be an office-sponsored event. You have to be very careful about the company doing anything that sets up a stage for people to get drunk and drive. Parties where alcohol is involved also do lead to sexual harassment claims at an alarming rate. Those events, they're fun, but you really have to be on the ball because they can set the stage for claims. Yeah.
Roger, I wonder if I could just finish the interview with asking you a couple of questions. What I really wanted to know, what I'm hoping our listeners will want to know, is what the top attributes are for somebody who is in a CEO role.
So are you asking me what would someone want to do to become a CEO or somebody who's in the role to succeed?
Well, I think both. I think it'd be interesting to get your perspective on the skill set that enabled you to reach the role that you have, and then separately, in the role that you have, what attributes do you think are most important?
Okay. I think in order to climb the ladder to become a CEO of any organization, unless you just simply have lots of money and you can build your own, you need to be the kind of person who is, first of all, a self-starter. You've got to have the attributes of good judgment, integrity. You've got to have good core values that cause people to notice you as a person who is trustworthy to lead. When opportunities arise to take on responsibilities, you need to take those on happily and to knock yourself out to do a great job. I would say my career track was marked by not seeking leadership, because I seriously never, ever sought a leadership role. It was that the firm asked me to do something, and I did it happily and willingly, and I did it really well. Then they asked me to do something else. Then they asked me to take on a broader set of responsibilities, and people noticed that. I think that's a very good way to advance, not to strive and not to compete and not to throw elbows and be seen as somebody who's a climber. I think that is a super turnoff, and it makes people very suspicious of your motives. Just be a decent human being, work hard, do a good job, deliver a good product, and the world will notice.
Roger, thank you very much. Those were excellent comments.
You've been listening to The Future of Resolution, the podcast. You can follow The Future of Resolution on Miles Mediation and Arbitration's Instagram, Twitter, and Facebook. If you haven't yet, go to Apple Podcast, Stitcher, Spotify, and subscribe, rate, or review this podcast. Join us soon for another interesting discussion. Thank you for listening.